Hey there. So, welcome to my Immigration Flash monthly edition. My name is Giselle Carson. I am a corporate immigration and talent strategist attorney. And if you are familiar with me, I have been sending almost weekly immigration flashes as a result of the ongoing rapid, unexpected changes in immigration policy. And I've decided that it would be a nice touch for all of you if I did a monthly immigration flash. They're intended to consolidate and update you on some of the key issues that are happening that you should be aware of and also provide some perspective. So, welcome to the first of this immigration flashes. And I have to tell you that I actually, some of you may be familiar with the book that I wrote last year. I don't know if you can see this, but the Corporate Immigration Advantage, How to Hire, Retain, and Thrive with Global Talent in a Competitive World. And obviously the topic of this is not about the book, but I mentioned the book because obviously for any of you that have wanting to write a book or have written a book, it's a labor of love. A lot of work goes into it. And the reason I wrote it, even before the significant changes that were happening right now in immigration, is because our country is a country of immigrants. It's an amazing melting pot that makes us the amazing country that we are. And I did a lot of research as I wrote this book about the importance of foreign talent in the United States. And then the book has a lot of statistics, but one of them is by 2040, the US will be short over 6 million working age people if we were to stop immigration. So solution, it is to one of the solutions obviously is to continue to advocate for business and people-centric immigration policies that are going to help us continue to grow and share the value that the US brings to those that live here and the world. So that's just the little intro before I go into the things that I wanted to talk to you about. A few things, and I have to kind of say, each case is unique. So what I'm giving you right now is not necessarily legal advice for a specific case, but certainly something that you can take into consideration as you make decisions. So here is the 4 things that I've decided that I was going to cover today. One, the ongoing government shutdown. As I record this, it's October 22nd, and the U.S. government has been shut down for 22 days and with no clear end in sight. And it is affecting, obviously, immigration processing, in particularly some agencies more than others. But as the shutdown continues, we're going to see more and more effects of the shutdown. And even when the government fully reopens, there's going to be a lot of backlogs and things that we're going to have to deal with. So here's a short recap. So as to the government shutdown, USCIS, so that's Citizenship and Immigration Services, is mostly operational. And I say mostly because we're also seeing delays in processing. And in fact, we're also seeing some requests for additional evidence that are totally unjustified. And I believe they're as a result of them being overwhelmed and wanting to buy time and not having to provide an adjudication within the 15 business days. And that's unfortunate, but it's something that we have seen before, and we're certainly seeing it again. But again, in general, it's mostly operational, and we are seeing cases, we're seeing cases being approved. And the bigger issue that is, I believe, affecting USCIS or filings with USCIS at this time is that new H-1B petitions, meaning not new for new employees, but a change of employer, an amendment, an extension, any of those require a labor certification that comes from a filing with the Department of Labor. And the Department of Labor is not operational, so that is affecting the USCIS filings. Now, just recently, like last week, USCIS issued a memo about some guidance with some flexibility on filings that may be affected by the LCAs. I take that with a grain of salt. I think we need more guidance, and there's a lot of other questions that are unanswered. As we stand today, we're kind of holding back. Our employers are holding back on our employer clients on filing a new H-1Bs that the LCA has not been. We didn't have an LCA from before. So again, USCIS partially operational, or mostly operational, I would say. Department of Labor not operating, and that is affecting the PERMs, basically green card processing, prevailing wage determinations, and as I just said, the LCA. And Department of State, that is where foreign nationals get their visa stamps, again, is mostly operational. They also receive fees, are fee funded. So when you pay to get a visa, that's what funds the operations. However, there are some consulates that may not have the sufficient funding. So you may see certain consulates that are just slowing down significantly. Again, operations all around are being affected. So what does that mean at the end of the day? That even if we were to see, the government reopening within the next days or weeks, which I hope is the case, we are going to continue to see some slowdowns and some backlogs as everything kind of, the machine re-oils itself and moves forward. So that is my update. Continue to be patient, continue to be alert to the changes. And those are my updates as it relates to the government shutdown. Now, the next topic that I'm going to talk about is the famous or infamous 100,000 H-1B added H-1B visa fee that was added as part of a proclamation from the government September 21st. And now, almost a month later, because actually literally a month later, because I believe it was October 21st or October 20th, that USCIS released guidance on how does this apply. So we've been waiting for a month after that proclamation to try to figure out what does this mean. And we still don't know for sure what does it mean. But what I'm going to tell you right now is what we believe we know. And also to let you know that this is an evolving process. Many lawsuits have been filed and are pending, challenging the authority of the president to issue this proclamation and for this fee, the economic harm. So there's a lot of arguments that are out there. But as we stand, this is kind of what it means. Some that we know or knew or assume, some that we have seen in practice. So in summary, in-country petitions. So that means the foreign national is in the United States present, and we are filing an extension, an amendment, a change of status, a change of employer that does not require or involve consular processing, meaning the person is in the United States and will stay in the United States once the petition is approved. Those cases are not subject to the 100K. and we have been filing those. We have been getting them approved. So that is for sure, in practicality, in practical terms, that is what's happening to those cases. Now, what about those that, and this is one of the biggest questions we had before, those that were in country, in the United States, have filed an extension, a change of employer, change of status, an amendment. With all of that taking place in the United States and now is approved, but the foreign national is going to travel abroad because they need visa stamping, so they're going to travel abroad for some reason, personal or whatever, and they need a visa stamp on their passport. Are they affected by this 100K? And the answer from the latest guidance is that those cases should not be affected. They should be able to go abroad, cancel a process, a new H-1B visa, and come back into the United States. So this at least opens the possibility for those that have been waiting for this guidance to travel. Now, I have to say this with caution, because this opening up of travel as it relates to the proclamation. However, as we have seen, and this is my warning, this administration is making unannounced, drastic, traumatic changes overnight, literally. And our government has a lot of power in restricting admissions to the United States. So anything else could happen. It could be some other travel ban, or it could be something else that restricts admissions for those that are abroad. So I am continuing to say, be very careful with traveling abroad, and only do it if it's necessary. If there is, no other way to do it, so just be very careful. The cases that are potentially the most concerning, and I hope at some point there is going to be more clarification on this, is cases that the person is not in country. So, or is in country but requires consular processing. So say the foreign national is abroad, they had to go abroad, for example, because they were going to have a gap in employment, or they had a gap in employment because of the Department of Labor taking so long to process perms, or for whatever reason. They had to leave the country, or they are abroad, and they were laid off, and they were on the 60 days grace period, and after that they left the United States. For those, when those H-1B petitions are being filed, they are considered new, and as we check consular processing, that is going to trigger the 100K fee. So again, for those that either in country or abroad, but they are going to need to consular process a visa, an H-1B visa stamp, those are the cases that currently appear to be the most affected or directly affected by this proclamation. And it's kind of very unfortunate, and I'm still trying to understand, and many immigration attorneys and others trying to understand. This could be people that have had H-1B visas for a very long time, even an I-140 approved, so an immigrant petition, and now for some reason are abroad and need to come back to the United States, and supposedly this 100K will apply. Certainly we're exploring more on this. How does it really apply? What are the workarounds, if any? You have probably heard that there is going to be national exceptions, and those national interest exceptions, according to the guidance, will be very rare. Not sure exactly what that means. We also don't know how to file them, and they are supposed to be either filed or pre-approved before the H-1B is filed. So a lot to unpack. we anticipate more guidance into the future, and obviously, results from the litigation, and see where that goes. But for now, again, in-country petitions with in-country changes of status, changes of employers, amendment extensions are fine. And even if those need to travel abroad to get visa stamping, they should be fine. Hope that helps at least a little bit. I know that I have sent some emails to foreign nationals and their employers where we have been waiting for this guidance to come in. And the responses back have been, oh, I am so relieved, thank you, that gives me peace of mind. So there is a little bit of hope, of lightness at the end of all of this. So that is my update on the 100K H-1B fee. Now, interestingly, this is also going to transition and affect the lottery, and it's difficult for me to say that this is going to affect the fiscal year 27. I believe I'm saying that right, yes. Because it's the fiscal year that begins October of next year. So fiscal year 27 H-1B cap lottery will be an interesting one for many reasons. There is a proposal for a weighted wage H-1B lottery, meaning that those with the higher wage, so the level 4s, would have four greater chances of getting selected at a level 1. That can create a lot of, and I shouldn't say anxiety, but many of our petitions are filed for level 1 wages because they're foreign nationals that are in the United States, have graduated top of their classes from very high and respected U.S. universities. But they're entry level. They're graduating just like a U.S. worker, and they're going into this specialized positions, but entry level positions. So they're level 1. And how would they be affected by the lottery was still to be determined. However, if the 100K is expected to affect mostly those that are coming from abroad, which is a significant portion of those H-1B cap cases, maybe this is going to balance out. So we're not sure. Again, this is all evolving. This weighted wage level actually is under public comment right now and is ending any day. So we'll see where that goes. So for now, stay alert as to what this is going to look like. It may not, considering all the regulatory process that needs to happen to change this, it may or may not be in effect for next year's lottery. We'll see. And last but not least, you may or may not have heard of Project Firewall. And this all relates to audits and raids and things. This Project Firewall was launched September 25th, so about a month ago. It's another enforcement initiative, basically giving the Department of Labor authority to investigate employers through audits and site visits. This already exists through USCIS. They have the power, and now a mandatory power, to perform site visits, investigate employers that have H-1B and L workers. So now they have added another agency that has the ability to do this. So as we go into 2026 and beyond, we expect, and we're actually seeing it, more coordination between the agencies. Some clients said to me, well, how are they going to know? Well, they know. The systems are a lot more connected now than they used to be. The government is using AI for various things. So we expect an ongoing coordination across the agencies, the DHS umbrellas of agencies, USCIS, DHS, USCIS, Department of State, and ICE, and also Department of Labor and everything else. Again, ongoing risk of audits and visits, and we're also seeing the raids. I will be providing, in fact, two enforcement boot camps to groups of employers and organizations. So if you're interested in some of those, please continue to follow me on LinkedIn. Where I post a lot of the trainings and things that I'm going to be involved in, so that you can also stay up to date. So those are the four things. So we talked about the government shutdown that is in effect and how that is impacting the immigration process now, and how we expect that it will continue to impact us even if they fully reopen. We talked about the latest guidance on the 100K H-1B and the little more than we know now that has opened a few little doors for some foreign nationals and their employers. We talked about the H-1B cap lottery for fiscal year 27 and the audits, Project Firewall raids. And this will continue. So if you're not subscribed to our YouTube channel, I encourage you to do that. I welcome also your emails and your comments on things that you want to know about, because that is how I prepare this content. And continue to follow me on LinkedIn. Also, again, you're welcome to DM me there. Let me know your thoughts. This content is created by you and for you. Until next time, thank you so much. Let's continue to grow and be positive. Take care. Bye-bye.